Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Toni Collins, an attorney in Texas, and we air on Tuesdays at noon. We are a show that is here to help the community and answer legal questions that y'all have as a service to the community. We can be heard on FM 104.5 and FM 106.1 on the radio, and you can also catch us on irlonestar.com if you go to the website, or you can go to our Facebook page, which is the legalconnectionshow.com. And if you also Google Legal Connection Show, you can get us on our YouTube. So if you miss part of this broadcast or you want to rewatch it, you can do it that way. So today's show is going to be on landlord-tenant issues, and I'm going to focus primarily on residential leases. But I'm going to touch on a few commercial issues. Before we get started, though, I wanted to give a shout out to a couple of people. First, to my co-host, Cheryl Christine Jihani. She hasn't been on the air lately with us. She's had some personal issues, but should be back soon. And just, wish her the recovery, and that, she should be in your prayers. Secondly, I wanted to let everyone know that the Shipley's Donuts on FM 1488, close to 2978, has free donuts on Tuesday, a free glazed donut. And I went there this morning to get my coffee, and I didn't get the usual dozen donuts for the crews I usually have working on my properties. But today I just got coffee, and you get a free donut. And I thought that was kind of nice. You don't even have to buy anything, I don't think. At least I got one free with coffee. And third, I wanted to give a shout out to Garcia's Construction, because Sergio Garcia owns Sergio Construction, and he has been just a lifesaver for me. It seems like he can do just about anything. We had two 80-foot trees fall on my she shed in my backyard. It destroyed it, and I couldn't replace it through my insurance, although it would have been covered, because my residential deductible is about $30,000. So the cost of the she shed would be about the same. So I had to start from scratch, and I was devastated because it was so cute the way I had it decked out. And he pretty much from scratch was able to put it back together again, even better than it was before. So I've got basically an air-conditioned loft she shed with a deck, and I've got he put a deck in that goes to my tennis court, a new gate to enter it, and it's just really adorable. And so just a shout out to him for always being there when some catastrophe happens, and he can come through and somehow knows how to fix it with his cousins. It might be his brother, but Pablo Garcia and Ramon Garcia, Pedro Garcia, all the Garcia clan are amazing. And so I wanted to just say thank you to them for always being there and being so helpful and reasonably priced. Okay, so I had a question from one of my clients who is leasing a residence, and it's got mold or mildew. Mold and mildew, they're kind of the same. I need to get into the scientific breakdown, but regardless, it could be black mold because it's pretty bad, and it's in the residential property that she's leasing. Usually that would make it uninhabitable, but in this instance, it's in a detached garage. And so her question was, what can I do about that? Part of the facts go to her having renewed the lease recently, knowing that there was a mold issue and not addressing that be fixed first. Could be that it was just the cost to move was too much, and she was comfortable, and her kids were already in the school system where she leased. I'm not really quite sure about what the facts are and why she renewed a lease when it already had a defect in it. But here's how you would typically handle it. you have, depending on what the lease says, because a landlord tenant situation is usually contractual, but you also have some statutory protections. And so, from a statutory standpoint, it has to be habitable. If it's not habitable and it's not fixed with the proper notices by your landlord, then there's certain other remedies that you have. But I'm going to go with, I went ahead and I looked it up in this particular situation, and I went to Texas Law Help, mainly because when I was looking up the cases, I realized that it wasn't getting right to a real good legal answer that I could give you that was succinct. And a lot of times I go to the Texas Secretary of State, I go to Texas Law Help, I'll go to Lexis, I'll go to Westlaw. Sometimes I'll ask my colleagues. In this case, Texas Law Help really had the best frequently asked questions on it, and you might have the same situation. So I'm going to just kind of throw out there what these answers were. Okay, so the question was, does a landlord have to remove mold from a rental property in Texas? And I'm going to go ahead and distinguish this from a commercial property. Residential has got many more statutory protections because you're living there than a commercial property, which is going to be, while there is some statutory protection, it's guided more by the contract that you entered. So it's really, really important when you enter a commercial lease that you look at that very carefully on who has to repair what. There is typically, you're going to be held to the having inspected it beforehand, to know if there was any visual problems, and if it was a latent defects. If your landlord fixes it within a certain notice period, then it's usually going to be worked out that way. So we'll get into that in a little bit. That'll be the next segment that we cover today. But as far as mold goes, the law says that landlords in Texas have a duty to remove conditions that, quote, materially affect the physical health or safety of an ordinary tenant if all of the following are true. One, the condition was not caused by the tenant's family, or the tenant's guest. In other words, they didn't bring the mold situation in. It wasn't on their clothes. They didn't create it by something falling on the roof, and there have been a leak or what have you, as long as the causation wasn't the tenant's. Number two, the landlord has proper written notice of the condition. So you have to let your landlord know, not just verbally, but in writing, of the problem. Without that, you really don't have something to hold up in court. So you really have to put in writing, usually an email. These days, for like the last 20 years, an email is sufficient if it's in the lease that there's a contact. That's how you communicate. Even text, if that's how you have ordinarily communicated, will be sufficient if it's in writing. And it's expressed and specific enough that it can be identified, because you're looking to make sure that it will hold up in court if you have to go that direction. And third, the tenant is not delinquent in rent at the time of giving the landlord notice to repair the remedy. And all of this can be found under the Texas Property Code, section 92.056. 92.056 deals with residential lease issues and remedies. So that's why this particular code is going to go toward this issue. Now, how much time, let's say that all those things fall into place. The tenant didn't cause it. It was already there. Let's say it was just a leak in the roof. The tenant gave the landlord written notice of the condition, that, it was moldy. Let's say that they weren't put on notice, and this is the way they were on notice. I doubt when this particular girl renewed her lease, she put in the lease, there's mold in the 2-car, 3-car garage or whatever, although she should have. So let's just go with that wasn't addressed at the time that the lease was renewed. So she needs to now put that the landlord on notice in writing, and that let's say this tenant is current on her rent. She's not withholding rent. I guess ostensibly because she's saying that I need to repair this. So, and remember, withholding rent is generally going to be mutually exclusive of a repair if you haven't met these first two conditions. All right. So, how much time does a landlord have to remove the mold from somebody's from the leased premises? And I'm going to go kind of out on a limb here and let's say the mold is really bad and it's black mold. It used to be that was, well, actually it still is the case, that would make the property uninhabitable because there've been so much law and case studies and actual events that have occurred where people have gotten sick and died from being in a place that has mold. This black mold is really lethal. And it used to be that the black mold was not an exclusion to an insurance policy. And I know that because my sister back in I want to say it was around about 20 years ago, had her own property that she had an insurance policy on, and her I don't know what happened. I guess she didn't fix her roof or whatever. The insurance company immediately came out in her bathroom. She just thought she had some mold in her bathroom from not cleaning or whatever the case may be. But that's where they went to look at maybe there was a leak in there. They immediately removed them from the house. Put them into a new rental property that they paid for under the insurance, and in effect rebuilt their house. They had to tear out all of the infrastructure and replaced it with all new infrastructure that didn't have the mold in it. It's really hard to get rid of black mold. I think asbestos might be the same thing, but they don't really use. And lead paint's the same way. I think lead paint, asbestos, and black mold are the kind of things that you just have to take the whole thing out because the remedial work on it is so expensive. Anyway, my sister was moved by this insurance company. I can't remember who it was at the time. It was like Allstate or something, one of the big ones. They moved her into a rental property for a full year while they rebuilt her house. And there was no cost to my sister. I'm not even sure if she had any deductible on it. If she did, it was minimal compared to what the work that they did. And they just took it off the top of I guess paying the contractors, and she basically had a brand new house. And after that, it became such an issue in Texas, and I don't know why. She just kind of hit this wave of black mold before it became something that they took off insurance policies. But these days, black mold is not covered by insurance policies generally, unless you get a rider if you want to pay extra for it. And I think the same thing applies to flooding and various other issues that you can get a rider to cover. Like we have, for my residential property, we have a flood insurance. It's not even a rider. It may be through a different insurance company, but we have flood insurance now. We're not even in a flood zone, and we have it because you just don't know, living in Montgomery County with all the creeks and the rivers and the St. Jacinto West Fork, and what we had with Harvey, with with them closing the gates on the different dams that they built to create Lake Houston, Livingston, and Lake Conroe. You just don't know. So we have it anyway, and it's well worth it if you live in Montgomery County to cover yourself that way. So, but that being said, if your landlord has insurance for mold or mildew, or you have renter's insurance that may cover that, this would not be something that will be an issue because it'll already be taken care of. But how much? But the question is, how much time does a landlord have to remove mold from a leased property, a leased premises? Now, and the answer is it depends on how you send the notice to the landlord to repair or remedy the problem, and on the circumstances of the condition and its repair. That sounds like a lot of gobbledygook, but really that just says it depends. The landlord has a reasonable amount of time to remove the mold after receiving the tenant's notice. If the tenant sent the notice by certified mail, return receipt, or other method with tracking, or the tenant sent a second written notice after waiting a reasonable amount of time after sending a written notice. And this goes on to say that there's a tip. If you send your first notice by certified mail, mail receipt, or other method with tracking, you are not required to send a second notice to your landlord. However, you should try getting the problem fixed as quickly as possible by talking with or calling the landlord. However, to protect your rights to repair under Texas law, and that again can be found in the Texas Property Code under Chapter 52, it is very important that you give the landlord written notice, preferably by certified mail, return receipt, or other method with tracking. Okay. Then that didn't really answer the actual question we asked. How much time do they have? That's just the type of notice that you give. In order for if you have a claim and there is a resulting injury, generally when you have a civil case like this, there has to be an injury. You can't just say, I'm mad I have mold. You have to prove that you had an injury from it. Your furniture was damaged, you got sick. So it's like all things in court. You have to have a resulting damage or injury. But so the Texas Law Help Group goes on to answer their actual, I would say to that answer, objection non-responsive. But here they're actually answering the question in the next section. It says, what is considered a reasonable amount of time to make a repair or remedy a problem? 7 days is generally considered a reasonable amount of time. However, the court can consider a different length of time to be reasonable based on 1, the date the landlord received notice, 2, the severity and the nature of the condition, and 3, the reasonable availability of materials and labor and of the utilities access. So the example would be that Hurricane Harvey came in and everybody was affected by this, and your house flooded, and it was a rental property. So you in that situation, you want to give your landlord written notice, but you can't live in your house because it's dangerous. You've got electricity, live wires. You certainly can't live in something that's flooded. But this was an act of God, and so this wasn't the landlord's fault. It was just something that happened. But if your lease requires that they repair damages like that, then the court's going to consider this. When Harvey hit, the landlords can only do so much because they're also experiencing the same things at probably their own home if they live in the area. And of course, the availability of materials and labor and access to fix it are going to be very different. So you're going to have some self-help issues here. You have to use common sense. If you sent the notice, which would be, and even during the recent freezes that we've had in this February and the big freeze we had in February of 2021, you'd still want to follow these guidelines, but they're going to know. So definitely follow the statutory guidelines. Follow the contractual events that are in your lease, because if your lease says that this is going to override the statute, you'd still by statute have to be able to live in it, and the landlord would need to make it habitable, unless there was some as is, you got the rent, such a deal going that your contract may prevail. So it just really depends on those circumstances. If you have a typical HAR promulgated lease, though, these provisions are going to prevail. Now, it also, the Texas Law Group gives you some more exceptions. It says exceptions apply to the timing to complete a repair if the damage to the rental property was an insured casualty loss. If the mold problem is a covered condition, the landlord has a reasonable amount of time after receiving the insurance proceeds to complete the repairs. So now we've got a third party, the insurance group, that's looking at this. Me being the landlord, I wouldn't wait on the insurance proceeds. I would try to make sure that my tenants were safe before I would be relying upon the timing of the insurance company proceeds to come in. I will say this, though. The insurance code requires that the insurance company pretty quickly remedy these problems, and the proceeds come pretty quick, too. So, again, it's all sort of relative, and you have to look at all the players that are involved. This goes on to say to talk with the lawyer about your right to end your lease before the problem is corrected and receive a rent reduction if the property becomes totally unusable during the time your landlord is waiting for the insurance proceeds to make the repair. Now, what options do I have if my landlord refuses to remove the mold from my lease premises? Here are the options. There's statutory options, but you also, once again, want to look at the contractual provisions in the lease. The first one is end your lease and move. You've got to use common sense here. If you have a sick child, one that's, I guess, more susceptible than the ordinary child to getting sick. Let's say they've got an autoimmune issue, they've got asthma, they are, they're disabled and they can't deal with, having mold, spurs or mildew in the air. Then, of course, you want to protect the safety of your child and move. All right. The second thing is to file a lawsuit against the landlord in court. This is assuming that you've talked with the landlord and they won't remedy the issue, that they didn't know in advance, or you didn't have something in your contract that provides for your sick child or another family member. The third thing is hire a contractor to repair the mold and deduct the cost of the repair from your rent. And you can do that once you have already worked with your landlord and they haven't timely repaired the mold issue, or you have that option of your lease. You have to look at your lease there. You can't just go in and do it. So because the statute and the generally your lease contract might not allow you to do the work without contacting your landlord first. Why? Because it's not, while you have the right, it's a bundle of rights to enjoy, undisturbed access, right of quiet enjoyment of the property while you're leasing it, you don't have the right to make improvements and repairs without getting with the actual owner of the property first, generally. I'm still saying that I don't know without looking at your contract where you fall, but generally you need to get with the owner because it's not, you can't just go in there and do this. It could be that the landlord is a contractor and can do it quickly and efficiently and effectively without the overhead that would be paid to the contractor that you may choose. And if you go and do that, you may be only to be reimbursed reasonably. A court would look at it like this for the amount that the landlord would pay as their, I want to say like their, not their wholesale cost, whatever the cost would be to them. There wouldn't be the additional profit margin that you would pay an outside contractor. So you can only do this under very specific circumstances too, as I was saying. Talk with a landlord-tenant lawyer before you move forward with the above options if the landlord refuses a repair of a hazardous mold condition. This Texas Law Help goes on to say if you need to talk to a lawyer for free for a referral service, you can go to texaslawhelp.org. They have lawyer referral services. If you do get a free lawyer through Texas Law Help, or you want to go through the different free, I want to say they're free through taxpayer money a lot of times, but this is a service, just this radio show. If you want to go through their service, though, sometimes you have to wait in line, so it may not be time effective. And in life, as you know, time is probably the most important thing in life and in real estate, even more so than location, because time is limited and you can't take it back. Time is the difference between you getting sick or, think about it in terms of the example of you're out in the middle of the ocean and you're drowning. It could be 1 second between the time of you drowning and you surviving. So time is probably the most important thing you have in life. So time is pertinent and is of the essence. You can also go to a legal clinic, and if you go to one of the free legal clinics, you can call South Texas College has a legal clinic. There's also one with University of Houston. They have different ones with Montgomery County. Contact in Montgomery County, the Montgomery County legal aid. I believe you can go across the street from the courthouse up here, and if you walk to the library, they can give you some guidance on who you can contact to try to get some free legal advice. They're really, really good at the Montgomery County Library, not the Montgomery County Library, but the Montgomery County Legal Library, which is directly across the street from the courthouse. So the next question is, can I remove the mold myself, which was kind of covered a little bit here, and reduce the amount I pay my landlord in rent that month? And the answer Texas Law Help gives is no. The repair and the deduct method is not automatic and only reduces a future rent payable if that is allowed under your lease. This method is not recommended without the advice of an attorney, and that's what we're kind of going over just now. It's not really your property. It's your property to use and enjoy, but it belongs to the landlord, so you can't go in and making repairs on it until it's been assessed. But certainly, if it's a life-threatening situation, get out. You don't want to stay and wait for your landlord. You want to you have to use your common sense. So if you want to have the mold removed and the landlord is refusing to remove it because maybe they've hired a contractor or a structural engineer that's determined that what you're calling a mold issue is really not a mold issue, then you want to, one, get a court order requiring the landlord to remove the mold. That means you can go to small claims court, which is up to $20,000 in damages these days. It doesn't cost you any money to actually file the suit in a JP court, which is going to be the court where the property is located. You can go to, if you literally go to Montgomery County, a JP court, you can put the address of the property in there and they'll tell you which court you file it in. You can these days, I believe, file it e-file. It's really great, but you still have to properly serve the landlord, which means you've got to pay $80 to a constable to serve it, the actual petition, or you can serve it properly under the rules of civil procedure, but it has to be done properly, and then you can file that return of service with the court. So you may not have to pay the $80. You might be able to serve it based on those rules and save some money. But you do want to get a proper lawsuit filed with the JP court. And I highly recommend using the JP court as opposed to the county court or the district court, just because it's less expensive and it's friendly to a tenant that has a little bit of a fear of the court system and doesn't have the same amount of money. It wants to represent themselves. And you can do this. You might want an attorney. If you do go to one of the legal clinics, they'll probably file it in JP court because it's less expensive and it has the same weight as a judgment or a suit that goes through the county courts or the district courts. Okay, so after if you can get a court order to have them remove the mold, that's one option. The second is follow the repair and deduct rules in Texas Property Code 92.0561. You can Google that and the law will actually come up for you. And it goes on to say, for an example, the limit, it will show you under that code that there is a limit to the rent reduction for the cost of the repair in any given month to the greater of 1 month's rent or $500 for the non-subsidized rent. Subsidized rent means that you are getting money, you're being subsidized by a government entity, whether it be the county, the city, the state, or the U.S. government. So it's or $500 for the non-subsidized rental part. Second, there's a limit to the rent deduction for the cost of the repair in any given month to the greater of the fair market value of 1 month's rent or $500 for subsidized rent. All right. Third, it only allows a tenant to repair and deduct if the landlord has a duty to repair and they have not timely fixed the problem. And fourth, that only allows the tenant to repair and deduct if the tenant did not waive his or her right to repair and an enforceable provision in the lease agreement. And you want to read Texas Property Code 92.006 E and F. So this gets kind of complicated going through this maze of things that you have to read in the property code. But the bottom line is you have some statutory remedies that you can follow if your lease doesn't provide for it and you actually do have a cause of action. There is an exception that exists if you and your landlord agreed in writing for you to repair a condition at the landlord's expense. And that, again, can be found in the Texas Property Code 92.0561. But again, this is just basically if you've agreed in writing, you have amended or modified or supplemented a lease condition in writing. So you have like a little side contract allowing it. So I, as an attorney, say always get everything in writing expressly as you can. You may have a problem if you're a tenant getting the landlord to agree in writing because they may be a little bit more savvy as a landlord, or you may be a tenant that does this all the time and gets your landlord for contractual repairs that may be not necessary because you're a contractor. So it all just is relative and it just depends. But to answer my friend's question about whether or not what her remedy is for mold in her garage, these are some of the things that she can do. But first and foremost, you want to, if you feel it's life-threatening, not go in there, and you want to get with your landlord to identify that this problem needs to be fixed. And if you've given them fair notice and they don't repair it, then you've got these remedies that are statutory to repair it. Certainly, you wouldn't have signed a lease saying, I agree to having mold in my garage if you had known about it, if you thought that it was life-threatening. So this is something that is a defect in the property, and you need to let your landlord know so they can fix it. Now, do I have to have the property inspected for mold removal to be covered by the landlord? Not always, and this goes toward my friend's question. Mold removal can be covered without an inspection where your landlord agreed to mold removal, which they may, or without an agreement if a court finds that the mold condition materially affects the physical health or safety of an ordinary tenant and lets you end your lease or get a court order requiring the mold removal. So we're still going to the JP court, and your landlord may not want to have to deal with all this. It almost is in your best interest if your landlord won't remove the mold and you've got a problem out there and you've had somebody come inspect it, that they're like, well, you've already signed the lease and I'm not going to deal with you anymore because you've already agreed to accept it. No, when you signed the lease, you didn't accept a defect in the property like that because you probably wouldn't have known as a normal, ordinary person that this could affect your kids and your health. So no, if you've put them on notice that there's a mold problem, that you didn't accept the lease as is, and even if you did, it should be repaired because it's their property. And you've also got a liability issue as a tenant. If you don't put them on notice that there's a problem with the property and it continues to deteriorate the condition of the property, you may be held liable for not giving the landlord notice to repair it. So you do have to put them on notice in writing and ask them to repair it. I mean, it's just the right thing to do. But if they don't, and you've got some question about it after talking to a lawyer, you can, email us at the show and we may be able to give you some help. And when I say us, I mean Christine Jahani, who's also a licensed attorney and deals with these premises liability issues and personal injury. They kind of go hand in hand. You can email the show and get a hold of me that way too, and we may be able to give you some guidance. Condition upon us not representing you unless you actually hire us. You do want to, it may be in your best interest just to go ahead and file a small claims case to let a court decide. Just like this says, if the landlord won't agree and you can't afford it, you may want to stay outside of that detached garage until you can get a court to decide for you. And the JP courts are really fast. You get in there and out of there like, if they think that there may be an issue with your health, they'll get you in there pretty quick. So don't discount going to court. If you file it and you get these and you properly serve the landlord, and that kind of will throw you into, because the courts like you to mediate a mediation situation where and they have a really inexpensive mediation that's done. It's a courtesy of Montgomery County with your taxpayer dollars. If you go up here and they have some pretty savvy mediators, you may be able to get it resolved that way. But if you go to court and you show you've had somebody look at it who is a structural engineer or an expert in this area of remediation for mold, and you have pictures and you show that your kids have had some health issues and you gave the written notice to your landlord and they won't cooperate, you could win a court judgment in your favor and be able to reduce it against your rent is what it looks like. But anyway, to go back to sort of more of the guidelines, if however you want to use the repair and deduct remedy, you must have the appropriate local housing, building, or health official or other official having jurisdiction provide the landlord with written notice of the mold condition material affects the health and safety of an ordinary tenant. This official might be a city health inspector, for an example. So if you're in the city of Conroe or the city of Magnolia, you want to ask for the city health inspector in addition, and they probably won't go out unless you've had somebody look at it first, but they might, to go out and actually say this is a health hazard. If it's outside the jurisdiction of the city and you're not within the ETJ of Conroe, and that would actually fall into my house, even though I don't rent my house out. But if you're outside the ETJ and you can look at if you fall outside the ETJ, you may not not know that as a tenant. There's all these maps of the city of Conroe in Montgomery County where it actually outlines it for you. And I believe that if you go into the Montgomery County site to figure out which jurisdiction you're in, and you put the address in, it will let you know. It gives you like a little list of whether you're in the ETJ or if you're in the city of Conroe and what JP court you fall into. It's the city of Montgomery County is extremely helpful, just online with the different applications that you can use that are available to the citizens and people and residences here. So utilize that. And if you have any questions, you're certainly, I'm certainly willing to help you if you want to email the station through the legalconnectionshow.com, and they'll get a hold of me and give me your questions, and I can answer those for you. Do go to, if you suspect anything, get your a city health inspector out. That's probably going to be something you'll need if you want to go to court over it. Now, what should I do if my health has been harmed by the hazardous mold? This is a landlord's worst nightmare. It's the city's worst nightmare. If somebody gets really sick and it's a condition that could have been mitigated, and health and safety is the first and foremost thing that should be on the mind of all city officials as well as your landlord, and as a parent, a teacher. I mean, this is what the whole reason we have laws and rules is so that people's health and their safety is health and safety and all their constitutional rights are taken care of, which is why, the United States is a great place to live, and particularly Texas. All right, so if you feel your health has been harmed due to hazardous, I mean, it's easy for you to say, mold exposure, talk with an experienced personal injury lawyer immediately. And there's where that kind of comes in. Premises liability attorneys are kind of on one side of the fence, and then you've got and they're going to be looking at, well, really it's going to be tenant and landlord, and then you've got your personal injury attorneys that tenant and landlord, it both applies depending on who was injured. You need to talk to them. And I say talk to them. Attorneys are really expensive. Personal injury attorneys are usually on contingency, but they're not going to take your case unless you actually have a legitimate case. So, and time, again, is of the essence. So if you don't be just piddling around looking for someone to take your case, just like you wouldn't in a car accident if you've got back problems or, paralysis that may be, pending because you've got, you got hit on the head and, you have a brain injury you didn't even know about. So it's good to talk to an attorney. It's good to exercise your right to talk to an attorney, especially if you've got criminal issues. You want to, you don't want to give out information that and I'm talking criminal now, to the prosecutors that it would, pursuant to your Fifth Amendment right, shouldn't be disclosed. An attorney is going to guide you from a civil standpoint on who you need to speak with, what documents you need to look at, but particularly if you don't have a case. A personal injury attorney on the civil side is going to be able to guide you, and they're not going to waste their own money if they don't think that there's actually a case there and it's something that's kind of simple. But an attorney would be able to guide you pretty quickly if you don't know. If you've got an issue that they will automatically be able to, well, I say automatically, they wouldn't be able to identify based on your facts is something that you need to look at through a medical standpoint and an issue of your safety. So don't not call them because you're worried, but do be aware that if you call a personal injury attorney, they generally work on contingency and they may not take your case, but they will guide you if it looks like there's an issue where you need an immediate attention of a doctor or perhaps a government help, whether it be the police or somebody else within the government. Okay, owners of property, such as your landlord, could potentially be held responsible for health effects if you are able to prove you suffered them due to exposure to hazardous conditions on the property. A personal injury attorney can help you determine if you have a toxic mold claim that is connected to your mold exposure. And, I've done a number of cases that relate to food poisoning and mold exposure and different premises liability issues, where it be a slip and fall or, I had some cases that dealt with elevators that weren't functioning properly, and there were serious injuries and death that were involved in an elevator that didn't work. But and that gets, you're just talking about cases that go on and on, because you've got to use your common sense. You've got to, have the correct warning signs, correct notices. With the slip and fall, you can't win them if you're in a grocery store, HEB or whatever, because there's so many con artists out there that throw water and grapes and stuff down just so that they will have a slip and fall, so they can get some kind of insurance fraud, and be able to hold a landlord with deep pockets accountable for the injuries that they fraudulently set up on their own. And so, a tenant did, or a person that's come onto the premises. So, and I was just thinking about all my different cases here. So if you've got these, a premises liability issue, you do need to, you can't be the person that created the problem, but you also want to make sure that you talk to an attorney and the right people to make sure that you've actually got a case. Toxic mold is one of those where it could be that they're going to say, the landlord's going to be he said, she said, unless you've got really good documentation. The landlord will say, you knew about it and accepted the condition. You knew about it. You caused it and knew about it, and you've hurt my property. Now you've hurt me too. So you have to look at the different ways that this can be looked at and go forward with those facts. Since gathering of evidence and environmental testing is critical to toxic mold issue, these are things that you need to look at before you actually want to go forward with the claim. Information on mold and toxins is also something that's covered by the Center for Disease Control site. So look at that too. They've got a lot of information out there. That's under www.cdc.gov. And there is it's a long line. So if you're ready, it is www.cdc.gov /NCEH /publications /books /housing /CHA05. And that's a long place to have to go look, when I think you can just Google mold and toxin CDC disease control, and it will bring you to where you need to look. You can also get more information on your rights if something like that happens with the Office of the Attorney General, tenant rights. You can go to the Austin's Tenants Council. I don't know if they have one in Montgomery County, but you can also go to the Texas Young Lawyers Association for Tenants' Rights handout. They have all kind of information that may help you. And they may, actually, if you go to the Texas Young Lawyers Association, they've got some people on call that they can get. I guess when you do this pro bono work, I've gotten them a number of times. You get, with the number of the amount of work that you do, you can get CLE credits if you're an attorney, and so they may be there to help you free of charge, and also a phone answering service for you. Now that also leads me to the COVID issue and evictions that has come up recently because of, the moratorium and what have you. And I want to check with Station Manager Dick and find out how much time I have to address this one issue. It's going to take me about 10 minutes. He says I've got 10 minutes. So I'm going to address that issue now. We've gone over a number of the tenant protections in previous shows with regard to COVID. And, for a long time, we had a number of these emergency orders through Texas and the federal government that had to do with the Texas eviction diversion program. And basically what that means, it's the long words for, your landlord could not evict you during COVID because there was a moratorium that prevented them from doing so, no matter what your lease said, because for a number of reasons, but it was primarily because they didn't want to spread COVID, and so many people were out of work or couldn't work that there were rental help and rental relief agencies that were well funded that could allow you to stay. And if your landlord to agree to receive rent from them, because they didn't expect without you working, and they had these moratoriums in place, that they were willing to go ahead and be in that program and accept that money in lieu of rent. And these rent relief programs basically paid your rent for you. And this went on for about a year or two. You could actually get free rent if you played your cards right and applied through the proper rent relief programs and the rental assistance programs and filled out the proper affidavits. You didn't have to pay rent. Well, those have because the vaccines have come in place, and the even with the new strains of COVID, they are phasing out. People are working again, and so there is still some tenant protections through the emergency orders through Texas, and I want to talk about those a little bit. I will say that I've been watching, and I kind of have while I'm doing different pleadings, I'll watch the different courts online. They're still live online. A lot of them are giving that option to attorneys and tenants to have their cases online, particularly in Harris County, where they're a little bit more liberal. Not so much in Montgomery County. You may want to be online, but you don't have that option anymore in Montgomery County. You've got to go in person. Harris County's still doing it, so I get to watch, and you can too if you put Harris County live streams up. If you just Google that, it will pull up all the JP courts in Harris County. All of the criminal county courts and all of the civil county courts. And so you've got a broad brush of cases that are coming up that you can watch. If the little green camera light comes on, that means the court is open and you can watch these live cases. It's really fascinating. It's good for you to know. If you go to the JP courts, you'll see mostly eviction cases. You'll see a lot of you'll see whatever they'll actually have in the JP courts, which is, a broad range of cases that can be brought before the court. But only JP courts have jurisdiction over eviction cases. They're called forcible entry and detainer cases. And if you are evicted and you don't agree with the eviction, then you can go a step further and appeal it to the county court. And I wanted to go over that briefly, but just to talk about in particular what I was seeing. I'm seeing that the moratoriums are no longer in place, that people are being evicted all the time now. There's no longer, I've got a disabled mother and we have no place to go and I've been sick and I can't find work, and all the excuses you had during COVID, they don't work anymore. The courts are evicting everybody now. There's no get out of jail free card, so to speak. And I had I'd actually printed some cases on it. Because it was today COVID doesn't work. That's just the bottom line. And a couple of things that you need to know are that there is a House bill that was passed effective September of 2021 that eliminates all landlord liability for destroying the tenant's possessions during an eviction. So these people are getting eviction notices, and a lot of them are relying on, I'll just be able to, ignore this because everybody's been during COVID. They'll let me stay a little bit longer because the judges did before and they were so nice. Oh no, the judges are evicting everybody now if you don't have some valid excuse. And I'll tell you what one option is to get out of it now. But one of the main things with the eviction process is if you have been evicted in JP court, you don't take it seriously, or you were able to hold off with the COVID moratorium before, you can always, if you file a pauper's affidavit, so you don't have to pay any rent into the court registry, and you qualify, you can appeal the eviction into county court. So that buys you a little bit of time to prepare, so you don't get the writ of possession that's basically going to kick you out. What happens is if you just ignore this and the landlord gets a writ of possession, they can literally, with this new House bill and statute, just put your stuff out on the street, and they can do it pretty, they have no liability under this new House bill. It eliminates all landlord liability for destroying your possessions during eviction, because you've had notice. You need to get your stuff out. It doesn't matter if you're sick or you don't have work and you don't play ghost, or you're homeless or COVID. There are no more excuses for you. Now, that's the first thing to know. Take it seriously. They can do pretty much whatever they want with your property. The landlord can, if they've got that writ of possession or and you didn't appeal properly. Number two, evictions in Texas have increased as protections expire and rent relief funds run out. And if your landlord elects not to opt in to the rental relief program, even if you've qualified for it, they can get rid of your stuff. Number 3, meaning you will be evicted and your stuff they can claim it. I don't know. I say they can claim it. There's some other statutory rules about it, but they can put it. They basically, your possessions are, if they get destroyed or I guess injured, if you want to call it that, if your personal property is damaged, your landlord's not liable for that, even if they follow all the statutory rules for where they put it. All right. Tenants' rights groups say abusive practices in rental housing industry are very common in Texas because we are a landlord-friendly state, so beware of that. And finally, renters experiencing writ of possession say landlords are careless with their belongings and they get away with it, and it is true. And there was an article that basically was going on to say that that the landlords, this lady had gotten approval through the rental housing. Let me see, what did she say here? She goes on to say that that the and I'll just have to read this article because it's going to say it better and more succinctly. Tenants' rights advocates say that that the new law that let me go backward. This new law that came into effect last session, which is in September. I think it was September 1st, 2021, but it's in effect right now, eliminates liability for landlords during a writ of possession, which legally allows the forcible removal of a tenant and their property out of a rental unit if they have failed to leave by the court-ordered eviction date, okay? And that, of course, is going to be lifted if you appeal. But if you are found not to have paid your rent and the eviction stands because your landlord has properly served you notice and you've gone to court and the court finds that the proper process has been taken for the eviction process, whether it be because you didn't pay your rent or you didn't comply with some term, then this is important to know that the landlord, they've got this new law in there that comes into place. Tenant right advocates say that this is letting landlords get away with reckless behavior. Those in favor of the law say landlords shouldn't be responsible for what happens during a lawful process. In other words, the landlord says, it's my property, you didn't pay rent, I've got my legal writ of possession, you didn't get out within the 10 days that you were given or whatever that date may be. Sometimes the landlord gives you a little bit longer. If you're sick or whatever, you can talk them into it, and I've seen them do that too. Then you need to move your stuff and take precautions, all right? On the other hand, there are tenants like the woman that we're going to talk about, her name was Shanna Alexander, who said that the process isn't fair to begin with. On the day that she met up with the mother, on the day that the property, the person that was writing this article met up with this woman, who said the process wasn't fair, and she has 2 small children. She got a surprise visit from the constable. So the very day that this news person showed up to talk to her, the constable also showed up to evict her. She was served with the eviction suit, and it went on to say that it's not her first one. So she's familiar with the eviction process, so she should have known this already. It said from the 19th of October on, and so this was, this article is a little bit older. Actually, it was written, this says March 8th, so it's fairly new. She's had 2 evictions notices. Alexander had just signed the lease to the apartment that she is staying in now after she was evicted from her last apartment less than a month ago. So this was a month-by-month lease, and she was just going where she could. She has 2 daughters with special needs. Alexander gets child tax credits, so that's showing she's getting something from the government to help her with her special needs children, but it's still not enough for rent for her to support her family. Both her parents died recently, so she's without child care and it's hard for her to work. So these are all the things that you would tell the judge when you go to the eviction. She goes on to say she's had so many problems. Alexander applied for Texas rent relief back in August, which it was still in place back then, so that would make sense. And many of the courts were saying that if your landlord is in the program, has agreed to participate in the program, that they cannot evict you. And I will say, even recently, if the landlord accepted rent from the rent relief program and they had an eviction on file, they still cannot evict you, even if they received it yesterday and the eviction trial was going on today, they have to refile the whole process because they've received rent, even if it wasn't all the rent. The judges, pursuant to the it looks like the 48th emergency order, cannot evict you if they are participants in the rent relief program and accepted rent. If the rent relief program sent rent and they were participants and they sent it back saying, I don't want to do it anymore because the rent relief programs are running out of money, then they still cannot evict you. At any rate, this woman is saying that she got an email notifying her that she qualified for the back rent, and her hearing was the next day. The court ruled in the landlord's favor and got a writ of possession. So it didn't do any good that she was qualified for the rent relief program and they were going to send money. The landlord was no longer in the rent relief program, and so her eviction was going forward. And so what we're going to do, because station manager Dick is telling me that I'm out of time, we're going to talk next show about the 48th emergency relief order, what some of your options are if you're being evicted, and we're also going to talk about commercial leases and the responsibilities and liabilities for both the tenant and the landlord on commercial property. So we'll talk to you next time. Remember to serve God by serving others, and we'll see you next Tuesday.